People versus Tolentino. Counsel, you want any rebuttal time?
Yes, please. 3 minutes.
Okay. Go ahead.
Good afternoon. My name is Christina Schwarz. I work for the Legal Aid Society, and I represent appellant Jose Tolentino. Appellant's suppression motion set forth that his car was pulled over without cause and that officers that seized him obtained information concerning his identity that led them.
The court granted the Dunaway hearing, right? But it never occurred, the hearing. He pled before there was a hearing.
That's right. The Dunaway Huntley hearing was granted.
Right.
We don't have a court finding that this was an arrest without probable cause. He entered a plea before that determination, correct?
Yes, that is correct. So
we're just assuming that, I presume.
Right. We're basing whether his motion papers were sufficient to entitle him to a hearing.
So if you win, what you get is a hearing.
Yes, that's right.
And what are you seeking to suppress? What evidence exactly?
The Department of Motor Vehicle records.
What about the pedigree information? Seeking to suppress that also? Which led to?
Yes, we would.
You want to suppress his name? You want to suppress the fact that his name is Jose Tolentino?
That I don't think we can, based on the.
That of course is what led. I mean, that's all they needed to get the record suspension, or maybe they needed his date of birth.
Or his Social Security number or something. I'm not sure what.
Okay, well, the record doesn't seem to show exactly but I guess I gather from the record they pulled him over and they said, give me your name and date of birth and Social Security number, and he either told them or showed them some piece of paper. I mean, is that what happened, or don't we know?
We don't know from the record below.
We should assume it's something like that?
Something like that, I think is.
They couldn't do it just off the license?
I'm sorry?
They couldn't get the records just from the information on the license?
Well, I know that the statement that he made was, I don't have a New York State driver's license, so I don't think there was one. But I think that that what they do is they take identifying information, whatever they're given. I suppose a name that is a very common name, they need maybe more identifying information. In the case of the Oliveras Rangel, they took fingerprints, which is a more sophisticated identifying property, but they took identifying properties, and that led to the derivative evidence, the DMV records.
Do you also want to suppress the officer's observations?
Well, that wasn't asked for below, but that's interesting because in the Florida State case, they suppressed those observations and
the observations of the fact that he was driving the car.
Yes.
Aren't you on stronger ground there? I mean, that's not his identity. That's actual evidence of the crime.
Yeah. Yes. If I was drafting the motion, I would have asked to suppress those observations. Yes.
But the motor vehicle records, to simplify it, let's assume that all they needed to get the motor vehicle records was his name. Maybe that's not true, but let's just assume it. I don't know how many Tolentinos there are out there. If they, and you admit they can get the name. No matter how illegal the search is, you can't suppress the name. No matter how illegal the arrest is, you can't suppress the name.
My reading of Lopez Mendoza and the Kerr-Frisbee doctrine would say that no, the name itself is not.
Okay, so does it make sense to say they can't suppress the name, but you can suppress information for which you already had? All you needed was the name to attach to link to it. I mean, they had the state had his driving records before they stopped him.
Well, other courts, notably the Federal Circuit courts that I've cited, Oliveras Rangel being the chief case, have found that pre-existing records in governmental files are suppressible. So,
isn't that going to lead to it? I mean, suppose you got a fugitive from justice, and they have a huge dossier showing that he's responsible for a major crime wave. They have a file full of 10 witnesses and movies of his committing the crime. He's arrested without probable cause, and they take not routine pedigree information. Their purpose in arresting him is to get is to find out whether this is the guy or not. And it's an illegal arrest, and it's an abuse, and it's outrageous, and it's bad police conduct, and they get his name. Have you now tainted all that evidence? Is he immune from prosecution for all his crimes?
Well, if the evidence that was acquired through the illegality led to that evidence, then yes, it would be subject to suppression. The question would be whether there was one of the exceptions, attenuation.
Yeah, but doesn't that seem problematic? I mean, aren't you giving? Well, I know the exclusionary rule does funny things, but isn't this a little too funny?
Well, it sounds to me, in the hypothetical that you were given, it may have fallen under one of the exceptions, the inevitable discovery or...
Well, whichever in section I'm going to change my hypothetical to get rid of it.
So I'm just saying there may be some exception that's extant that would have covered that. But in general, the suppression rule is very simple. If evidence is acquired through police illegality, then...
In my hypothetical, the only evidence they acquired through police illegality was the guy's name. They already had all the other evidence. Of course, the evidence was no good to them until they found out where the guy with that name was and put their hands on him.
Well, in this case, the investigating officers who pulled over the defendant didn't have access to those records prior to the illegal search. Someone in government may have had those documents, but they didn't have it.
Well, only because they didn't know who they'd pulled over. The minute they knew the name, they did have access.
Well, yes. So they could have done an investigation and had some sort of reasonable suspicion to pull him over to obtain this information legitimately. But because they didn't, because this was a flagrant violation.
And you're arguing that there's no attenuation.
Yes, yes.
This is directly 100% comes from the illegal search.
Yes, I don't see how you can find otherwise, that the motivation of the police.
So if they pull him over illegally, and that leads directly with no attenuation whatsoever, it's the suppression rule, period. It's suppressed.
Yes.
I think that happened. I'm probably going to be proven wrong, but I think that's what happened with Timothy McVeigh. I think he was driving down the street, and I think they stopped him, and obviously he got arrested and charged with a rather difficult crime.
Yeah.
Would we suppress all of that and let him go? If they stopped him for having his music too loud in his truck?
Well, this court in People v. Robinson and in Wren versus United States have made it very clear that in order to effectuate a lawful car stop, you need to have at least reasonable suspicion of a traffic infraction. It's a fairly minimal standard. And in most cases, I would suspect there would be some, if you're in...
But your answer to that, I mean, the perhaps outrageous hypothetical that Judge Piggott has given you, but your answer is yes, you would let Timothy McVeigh go, if indeed he was illegally arrested and that's the only reason they were able to pin the crime on him.
I believe so, yes. I do. And to get back to the reasons why this makes sense is that the computer records had been maintained prior to the illegal car stop, and that doesn't mean that the officers had access to them. And the question in determining a Fourth Amendment violation is whether the investigating officers had the right to pull them over. And there's lots and lots of files containing evidence, but that doesn't mean that the investigating officers knew of their existence, and in this case, they obviously didn't. It was a fishing expedition of some sort, according to the allegations in the defense motion.
Can we do anything here until we find out, until we have a factual determination that there was, that there was no reasonable suspicion to pull the car over? I mean, we can't do anything.
Right. Well, that's why a hearing should have been heard. The factual allegations set forth in defendant's motion made out.
So you want us to state what the law should be in the event that there is a violation?
Well, yes, and what I believe this case is here for is because my adversary would have you say that Department of Motor Vehicle records, pre-existing records, are not subject to, there cannot be suppressible
So you want us to
proofs.
reach that issue?
So that's the issue that I think that, you know, is the central issue in this case. And from our perspective, there's a clear difference between identification and identity-related evidence, and they've been blurred by my adversary. And Lopez-Mendoza makes it very clear that identity is not suppressible, but other derivative evidence.
There's quite a few other circuit courts that disagree.
Right. And
it's not just your adversary.
Yes, that's true.
There's 5 or 6 other circuit courts that have found these types of motor vehicle records are not subject to Fourth Amendment suppression.
Right. And 3 circuits were based on the faulty reading of Lopez-Mendoza, which is explained in my brief and is really explained clearly in Olivares-Torres. But it doesn't really even make sense when you think about it logically that when taken in context that all of the cases that the U.S. Supreme Court have approved of suppression where identity-related evidence was what was the fruit. Cruz was identity-related evidence. Davis was identity-related evidence.
Cruz holds, as I understand, 5 justices in Cruz said you cannot suppress the guy's face.
That's Frisbee-Kerr. Yeah. But nonetheless, they did suppress the identification evidence of the lineup and the photo array. That was suppressed. But they didn't suppress, and they said that they couldn't suppress his face. So.
But you said that if they had that if they'd used that face and run it through their supercomputer and it showed a whole stack of prior crimes, you could not use the evidence thus generated.
Well, I believe that's the state of the law. Of course, Justice Brennan, in his opinion, suggested that may be open to interpretation.
Regardless of where it leads, though, regardless to the more extreme situation, it just doesn't matter.
Well, in this case, the issues that
but like the hypotheticals you were given where it turns out it's a mass murderer or whatever it is.
Well, yeah, they're outrageous hypotheticals, and we're talking about, but normally in an investigation like that, there would be pre-existing files of police investigation already in existence that wouldn't have been tainted by the Fourth Amendment violation.
These license suspensions were pre-existing too, and you're saying they tainted because the link between them and this person driving this car is tainted.
Well, what I'm saying is that the DMV records are, by their very nature, the evidence is compiled and documentary evidence. That just is the nature of that evidence itself. They weren't compiled by the investigating officers in the pursuit of crime. It's the nature of documentary evidence to be compiled. So I think it's kind of mixing apples with oranges.
So that's a distinction you're making between the kind of hypotheticals you're given in your situation here?
Right. And for example, in Pleasant, this court said that the investigation that took place in the Bronx was not tainted by the investigation, the illegal seizure of the defendant in Suffolk County. And so, again, what you're saying in an investigation of some serious crime, there would be investigations, and if they're not tainted by the illegality,
okay.
that there would be evidence.
Okay,
but evidence that is clearly
You'll have your rebuttal time.
Thank you.
Counsel, proceed.
May it please the Court, Alan Mickey for the people.
Why would you resist a hearing here?
Because DMV records are not suppressible, so the hearing would have been, the hearing was granted to determine probable cause for the stop, but there would be no need for a hearing to determine whether the DMV records are suppressible, because they simply are not.
But all we would need here is whether the stop was legitimate or not. That's all we would need to know in order to move on to the next question.
But it's still, it would.
Just saying, even if it was a bad stop, it wouldn't matter. This can't be suppressed.
Correct. It would be.
Why isn't it a direct outcome of the illegality?
The direct outcome is because.
I mean, isn't it? There's no attenuation. It directly flows from the illegal stop. Why couldn't you suppress it?
Because
you can never suppress these kinds of records.
In these, for pre-existing government records, where they're obtained simply by getting someone's identity, then no. There's absent, I think the Supreme Court said, absent egregious violations of the Fourth Amendment, then evidence that is pre-existing and obtained simply by using someone's identity.
Well, you think Mendoza was correctly cited, Lopez Mendoza was correctly cited in this?
Yes, I think the appellate division is correct to cite that for the identity is not suppressible. In this case, Mr. Tolentino's name. And from Mr. Tolentino's name, simply running through the DMV computer, which the police have, and routinely do as traffic stops. This is not an investigatory search. This is more of an administrative search, where they simply go through the DMV records, see that Mr. Tolentino had an incredible amount of moving violations, and then move to arrest him.
With this, you would make the same argument if he had said, "I'm not telling you my name," and they'd beaten him up until he told them. There'd still be nothing to suppress?
Well, his name is not suppressible.
No matter what.
He would have other remedies.
Like an action for damages.
Yes. He would have action for damages, and also just the return effect simply of the police. My adversary seems to make it sound like the police were out on a fishing expedition. There is still, as the exclusionary rule says, there is an extreme deterrent effect here that would keep the police from conducting these fishing expeditions, which is if, for example, they pulled over Mr. Tolentino just to see if he had he was an unlicensed operator, and find drugs and guns in his backseat. That's excluded. All that remains is simply his DMV records in his violation.
What about the observations of the police officer? Assuming there's an illegal stop, what about the observations of the police officer?
Well,
we're just talking about this specific crime, which is driving with suspended license.
Right.
So an element of that is that he was observed driving. What about?
He's observed driving before any type of seizure takes place. So then the observation.
How do we know that from the record?
Well, just simply the police did not affect the seizure. They would have had to see him first to affect the seizure.
Maybe they just saw the car and heard the music. Maybe it had tinted windows. How do we know? I mean, isn't that what a hearing's about?
That could, but still, even if they still would get his name, and the name would lead into the DMV.
But I thought Judge Separik's question was, what about, assume for the sake of the argument, that they couldn't testify to anything before couldn't testify that he was driving the car, except for the seizure. Shouldn't they at least have a hearing on whether their testimony that he was driving the car could be suppressed?
I'm sorry, I guess I'm not.
This case goes to trial. He's charged with operating a vehicle while his license is suspended. You've got to prove he's operating the vehicle. You call a police officer to say, I saw him operating the vehicle. Suppose that the only observations that the police officer could testify to occurred after the illegal arrest and were a result of the illegal arrest. Shouldn't they be suppressed?
No, because I think the officer would be able to testify. We pulled over a car. It was a red car, a car. We proceeded to question the driver, and the defendant was sitting behind the wheel.
Well, what if it was parked? What if the car was parked?
Well, that's a different.
Well, the fact that he was sitting behind the wheel is the fruit of the illegal arrest, isn't it? They wouldn't have seen him sitting behind the wheel if they hadn't arrested him.
That's true. But again, the exclusionary rule, the impact here of suppressing these records is too extreme compared to the deterrent effect that the police would have.
But we have cases going both ways, so obviously we're going to decide whether it is suppressible or it's not suppressible. So assuming that we decide that it could be suppressible under certain circumstances, we still have to send this back for hearing to determine whether the stop was legal or not, correct?
Yes. The Court has no further questions. We ask that the lower court's decision be affirmed.
Okay.
Just a few points. The prosecutor has indicated that he mentioned that these were documents that were in the police computer, I think he said, but actually these were DMV files. They were not in the possession of law enforcement, and the files were maintained by the Department of Motor Vehicles. And this court has said in the context of Rosario and Brady material violations that evidence that is in the Department of Motor Vehicles control or in the Office of the Medical Examiner's Office was not in the control of law enforcement.
Is it a different case if these things were in a police computer?
It might be, but again, I think...
Why? What's the principle that distinguishes them?
Well, I don't really think it would make a difference because the bottom line is, the question is what evidence or what information did the investigating officers know, and unless there's some way that they had prior knowledge of that information, it really wouldn't be applicable.
Looking at it generally, though, what's the intrusion here? I mean, they find out that he's got a driver's license. That's kind of nice to know. They find out that he's driving without insurance. I mean, so if he gets in an accident and hits somebody, you know, they can't get compensation. That in this case, you know, for 11 times, you know, he apparently decides that he doesn't need a license. I mean, where's the intrusion?
Well, the intrusion is for everyone who would be subjected to unreasonable searches and seizures.
Right. So if I get pulled over, you know, for no reason, and they say license and registration, and I hand it to them, what's the intrusion?
Well, I mean, the Fourth Amendment guarantees us to be free from unreasonable searches and seizures.
Unreasonable?
And I think that there would be...
What's unreasonable about it? I guess
you just said if a police for an arbitrary reason pulled you over and inconvenienced you by and for sure made you a little uncomfortable, and you're on your way to a meeting or whatever, right. It's an inconvenience, and it is a minor one.
I can complain about the stop, but what about the fact that they look at my license and my driving record? What's the intrusion?
Maybe I'm not following you, but
but my point is this: that the only thing you find by getting the license and registration is things like this, that there are people who don't have them, and the rest of the public is put at risk because there's no insurance, the car is not properly registered, the person doesn't have a license, and to protect the public safety, all you say is unless you fit these, you know, you can't do it. So there's been no intrusion, unreasonable intrusion on this person's privacy. I guess that's the point of the lower court, because all it did is say, get off the road for the 12th time.
But in all of these Fourth Amendment violations where, you know, some contraband or, you know, incriminating evidence is observed, you could make that argument.
Well, no, your opponent's willing to concede that if they found a gun or, you know, anything else, that all goes.
Well, but my point is that the exclusionary rule, it doesn't help law-abiding citizens. It does help people who have incriminating evidence discovered because of it. But nonetheless, the reason it was formulated by the U.S. Supreme Court.
For your guy, the absence of a driver's license is like a gun or cocaine.
I mean, the policy reason behind it is exactly the same.
In the strange world of the exclusionary rule, it's good to have something like a gun or cocaine in your car, because then you have a remedy.
Well, exactly. There's something fairly ironic and not, you know, not logical to me, because if there is a violation, if the police have an unreasonable seizure of a car and driver's record is discovered, that's a fruit, and it should be suppressed. There's nothing analytically that distinguishes DMV records from other kinds of contraband.
But you're saying there's intrusion if they find nothing. It's just that there's nothing to suppress. So, right? You're saying
but they did find evidence.
When to Judge Pickett's question, you're saying, well, they pulled you over, and that was an intrusion and something that they shouldn't have done illegally.
And many times in these MAP hearings, after the evidence is heard during the hearing, they craft an appropriate remedy. And in your case, and I was just quickly looking at the motion that was written, they talked about the DMV records and other fruit. So I think that it is possible.
At one point, they do say, including observations of the defendant by police.
Oh, okay. I didn't have a chance to review that. But exactly. So in this case, And especially having the Florida case and other cases where they did suppress observations, that would be, the remedy that one would ask
Okay.
for.
Thanks, counsel. Thank you both.